Okay, welcome to Season 2, Episode 1 of the Be Your HR Best webinar series. Coming to you live here from the Tyson's Corner studios of BLC Digital Strategies. We got Todd Castleberry on the other side of this wall, our great producer, and Rachel Goodnight and Olivia Jannar also helping out put this thing together. So we really appreciate it. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up our firm's employment law practice.
Good afternoon, everyone. My name is Nick Johnson. I'm a partner here at Berenzweig Leonard, and I work with Declan in our firm's employment practice, and happy to be here.
Yeah, so Nick, you and I have been in the studio before for these Be Your HR Best. I actually had to check. It was a year ago today that we did one of these. It was obviously a very different scenario. A couple things were different presidential administration. I also remember Duke had just really wiped up in Clemson in basketball, and you came in that day. You came in that day, and you were definitely not on your A game, but I know you're coming off of a big win. Clemson beating Duke, and look at you, man.
We may be a basketball school.
He hasn't stopped smiling since that win. My goodness, how many texts did I get that night?
Yeah, maybe a few less grades between us too, but you know what?
I don't know about you, maybe not me. But anyway, so I was checking to see what we talked about a year ago today, and it's amazing how it's like Groundhog Day a little bit, because I looked at the outline that we did a year ago, and two of the topics that we were talking about were DEI. As well as remote work, managing the remote workforce. Wow. Today we're going to be talking about those obviously under very different contexts with a new administration. You'd have to live under a rock not to know that this is impacting workforces, whether it's federal employees, federal contractor employees, or just pure private sector employees. So we're going to talk about these issues. They are having real impacts. DEI has obviously been sort of a lightning rod, part of the culture wars for the last couple of years. But where we stand right now, it's not just three letters. It really does have real world impacts. And so that's what we want to talk to HR folks out there today about. Let's just jump right in. We have an hour. And we got a lot to cover. So let's talk about this. Changes to the DEI landscape. Why are we talking so much about this?
So there's been just a massive shakeup in the DEI landscape. Obviously, within days of the new administration taking over, there were executive orders issued, there were new appointments, and it's very clear to us as employment attorneys that DEI is a major priority of this administration and the heads of the various agencies. And really, from my perspective, I think there have been three key developments on the DEI front just in the first few weeks of this new year. And so first, you've got the executive order that a lot of people are talking about. The executive order, the January 21st executive order, ending illegal discrimination and restoring merit-based opportunity. That's one of the big ones. I think the second big thing impacting DEI is just the massive overhaul of the affirmative action program. Everything that the OFCCP
for contractors
used to be doing for government contractors. There's been some massive changes there. And third, there's been just a massive overhaul and just some changes at the EEOC, so the Federal Equal Opportunity Employment Commission. There was a new chair of the commission appointed, and that new chair, Andrea Lucas, she's made it very clear that one of her priorities is to investigate and kind of get rid of what this administration's viewing as illegal discrimination through these DEI programs.
So I think it's important. The question that I keep getting is, well, okay, is discrimination still illegal? Like, do we still have discrimination laws? And so let's take a step back. The short answer is 100%. Discrimination is illegal. Nothing that these executive orders have done have changed that. Title VII, the Age Discrimination in Employment Act, the Americans with Disabilities Act, those absolutely remain intact and very much alive. It's important to understand, though, like what's motivating the Trump administration on this. And so it's important to understand their view. You might have a different view. I might have a different view. It doesn't really matter, because if you're doing business with the federal government, or if you're a private employer that does not want enforcement action against you in the next few years, you got to understand the Trump view is this. Okay, we have long had discrimination laws on our books. You can't discriminate, meaning you cannot treat somebody differently based on their sex, race, national origin, religion, all the protected classifications that have expanded over time. Their view is that when you have DEI programs in their form that they don't like, which would be ones that favor one group over another, we are going to hire more women, we're going to hire more blacks, we're going to hire, they believe that by their nature violate the long settled discrimination laws. And so that's what they're trying to dismantle.
That's exactly right. And I think, too, a lot of it comes from the Supreme Court decision that came down under the Biden administration that found that affirmative action programs in the education context are illegal, unenforceable. And so, what they focus on is, we know quotas set aside. When you have employment policies that set preferences of one protected class over another, that's going to be problematic. And that's really what this administration is focusing on. And I think, look no further than the executive order that was issued. And so, I think on its face, that executive order did a number of things. First, it immediately terminated any DEI programs, policies in the federal government. So if there's any DEI initiatives in the federal government, those have since been terminated. Well, what I actually find interesting is that there is some very serious foreshadowing about what is to come for the private sector as well in that executive order. And so specifically, that executive order directs the Attorney General and all the various agencies to pretty much put together a report, and they have a deadline of May 21st, 2025.
Right around the corner, really.
Right around this report to basically put together and identify what they say are some of the most egregious and discriminatory offenders of these DEI principles. And so basically, you've got federal agencies that are going to be looking at private sector companies and identifying, okay, which of them are the most egregious under this administration's view of what's an illegal DEI program. What I find really interesting, too, is, they've now told each of these agencies, you need to identify up to 9 companies that will be subject to civil investigation. And so and
they want them to be very high-profile companies, the companies that we all know on a daily basis, Amazon, Disney. I'm just using their names. They're not necessarily on this list. But like those brand name companies, because they want to make an example out of them.
They want these big name companies, absolutely. And so, on its face, some people look at this executive order and say, oh, it only applies to the federal government. Absolutely not. Every company in America, every private sector company in America should be looking at their handbook right now. If you haven't done it already, take a look at it right after this podcast. But I mean, that's really what they're indicating is that DEI is under attack.
No doubt. And so you've got federal workplaces. We know that's where it's hitting most directly. A lot of our client base is government contractors, federal contractors who, rely on the federal government, have to play by the rules of the federal government. I sometimes say they're the guinea pigs when it comes to a lot of the endeavors from a new administration, because if very quickly they're able to impose these regulations through contract modifications, executive orders, they can get right to them because guess what? They have the purse strings. They pay them. And so federal contractors are the ones that have to act quicker even than pure private companies, because what's coming are these certifications. They basically are going to have to certify as a condition, a material condition of getting paid by the federal government, that they do not engage in any unlawful DEI, meaning they don't favor one group over another in any of their hiring decisions.
That's right. Yeah, and the Attorney General has come out and said that if you're found to be in violation of those certifications, they could pursue false claims acts against you for both civil and criminal. So that just shows you the seriousness of this and how high up the priority list this is for this administration.
So on a nuts and bolts thing, okay, so a federal contractor no longer has to do these affirmative action plans. Up until now, they've had to file reports saying how they affirmatively engage in efforts to hire more women. Race and gender are really kind of the big things.
Race and gender are the big ones, And so you no longer need to have those affirmative action programs for race and gender. You no longer need to submit your annual report to OFCCP, providing that data as to race and gender. But what's interesting is affirmative action programs as to veterans and individuals with disabilities remains intact for now. I mean,
those emanated from Congress, and so you can't do away with those through an executive order, and that's why they have stayed in. And frankly, I do think veterans are going to be bolstered throughout this administration. So you're right for now, and I've seen some intimations that maybe those two are going to either not be enforced or whatever. But I think veteran status, I hope disability also, but those two are exempt from that. The other thing that I've been getting questions on is, what about the EEO-1 reporting form? companies with 100 or more employees, or if you're a contractor, 50 or more employees, they have to file an EEO-1 data form, it's called. And all that basically is here is the data that lists, how many women employees, how many black employees, so it lists them by category. Those are still required to be filed because remember, that's just data. That's not asking you what have you done to increase those numbers. That's where the Trump administration is directing its efforts. Is you can't have affirmative action to increase the numbers, but you can still report the data as to your existing numbers.
That's right. Yeah, and another data point just to kind of share is that government contractors, it's not something that needs to be done immediately. You've got 90 days. Now, granted, that's a pretty short period of time, but they do have 90 days to account for these adjustments. So note that deadline.
So one thing that we should note also is the fact that this is all being done at the federal level. But as we know, representing companies that have employees all over the place, especially coming out of COVID. You've got workplaces spread out everywhere. You still got state laws. Yep. And I personally see a real clash coming between state and what's going on in the Trump administration. Talk about that a little.
No doubt. I mean, I think, on one hand, you've got the federal government coming out here and very, very clearly saying, hey, you cannot have any of these illegal DEI programs. We know that the EEOC, once they get some additional appointments in there, they're going to be issuing guidance on, what specifically they're looking private sector companies to do. But right now, you're kind of in limbo. I mean, it's a really difficult spot for a company to be in because, you've got some, if you look at every handbook in the country, you've got just countless state-specific addenda, some of which kind of may conflict with this recent executive order. And so it's a difficult time.
A good example is pay transparency laws.
Oh, yeah.
How many times have we sat in here talking about pay transparency?
What motivates that?
Seminars. Pay transparency at the federal level. And by pay transparency, those are laws that require you to put your we're getting live questions as we do this, so if we're distracted, that's why. We've got a great audience, by the way, here today. We've got probably the largest number of people watching.
Thank you all for joining.
And of course, then we're going to send it out all over the place and clog up your inbox. But anyways, what were we talking about? Oh, we're talking about pay transparency. At the federal level, pay transparency, meaning like we are going to require you to post your pay because the underpinnings of all these pay transparency laws is that there has been discrimination in way people have been paid. Women paid less than men. That's what historical data underpins these pay transparency laws. On the federal level, basically dead. But here's the problem. On the state level, Colorado and so many other states have these laws. And so you're kind of sitting and thinking to yourself as a company, my goodness, when I'm complying with Colorado's pay transparency law, am I engaging in a DEI prohibited practice such that if I'm a contractor and I sign that certification, am I making a material misrepresentation? I don't have the answers today. I mean, it's really a tough one, but these are things we wanted to identify. They will work themselves out. It's been a flurry of activity in 3 weeks. I suspect the dust will settle after a couple of months or perhaps a year, and people will have more clarity, but these are things they need to watch out for.
My prediction, and I anticipate that you're going to get guidance from the EEOC pretty soon. And so kind of what's going on right now is obviously you have the new chair, Andrea Lucas, who was recently appointed. You had two Democratic commissioners that were recently fired by President Trump. There may be some legal challenges with respect to that, but right now they don't have a quorum. And so eventually there is going to be a quorum. And once they get that quorum, they're going to be issuing guidance. And my prediction is, based on the stated priorities of the current chair of the EEOC, one of the number one priorities is kind of targeting this anti and illegal discrimination with these DEI programs. And so we have the executive order. It kind of gives some details. We're going to be looking for that guidance from the EEOC. And my guess is we're going to get it over the next couple of months to really some much needed guidance to companies here.
But even before we get that guidance, there are things that HR needs to be doing and companies need to be doing right away. I call them HR risk audits. But basically what you have to do is you've got to be able to look inside your company and say, where are my pressure points? Where do I have stuff in there that could catch the attention of the administration? If I'm a contractor, that could, screw me over and I end up losing work. Let's talk about that a little bit. HR risk audit. What kind of things should companies be doing right now?
Yeah. So, first things first, looking at your handbook. I think everybody needs to be looking at your handbook. A lot of companies, they had affirmative action programs, they had DEI programs, and you know what? They were probably implemented with the best of intentions. I think it's important to note here that, this administration has made it very clear that they're targeting illegal DEI. And so, we know from Supreme Court cases that, there's certain types of DEI programs that are just going to be per se impermissible. Anything, what we talked about, with a quota, with a set aside, a policy that prefers one protected class over the other. But there are a lot of other benefits to DEI programs. And that's a lot of the reasons why these companies set these up in the first place. The research is out there. Companies saw the data that if you have a diverse workforce, you're going to have a workplace that creates and fosters creativity. You're going to have different perspective. The benefits are there. The research is there. And so I think if you have policies that, let's just say, recruit in an underrepresented population or an underrepresented, group, that I don't view as illegal DEI. Now, again, it remains to be seen, the scope of all this when we get that additional guidance. But I think things like that are going to be okay for the time being. And so I think you really need to take a close look at your handbook. Okay, what exact policies do you have on DEI affirmative action? It goes broader than just handbooks. You got to look at your job postings. You got to look at your job applications. You got to look at your new hire onboarding materials.
Yeah, your website. Your website. Basic as that. I don't know the last time I've looked at BL's website. You know what I mean? You just don't like, as your own company, you just don't do it.
Yeah. So we got us playing Cornhole on that. Yeah.
We're playing Cornhole?
Yes. Yeah.
Fun, didn't I?
Yeah, that's right. Yeah. Another thing that we're getting questions on from the group, and actually we've had a number of clients reach out about this, is, you have these employee groups, right? Where, maybe under a prior administration, you set up employee, perhaps, some call them listening groups, employee resource groups. Think of it as a platform for people to get together, voice concerns. And I think, previously, you had some companies that maybe had, like a women's group that got together and talked about issues in the workplace. I think you need to tread carefully with those. I think the big focus now is inclusion.
Yeah.
And so if you're going to have those listening groups, and don't get me wrong, there's some real benefits to having them, you need to make sure that everyone in your workforce is included, is invited, that it's not limited to just one protected class, that you're excluding protected classes from that listening group.
Let's talk about a couple specific things that I've been fielding. It's February. Somebody said, well, what about Black History Month? Can we still celebrate that? Pam Bondi, the new Attorney General, has said that that is no problem whatsoever. Yeah. You can still celebrate diversity. You can still celebrate as long as part of that celebration, you don't say, you know what, in February we're actually going to hire more Black people than we are any other race, because that, they believe, engages in unlawful discrimination. So stuff like that. Let's talk about a lightning rod. These pronouns that people put in their signature block and things of that nature. We know that the administration has come after those. What should companies be doing there?
Yeah. So we know on the federal level, pronouns in email signature blocks have been banned. So for federal employees, no longer can you have pronouns in your signature blocks on emails. Sitting here today, there has not been any executive orders, guidance that is focused on the private sector, but we used the word foreshadowing before.
Yeah.
And I think look no further than what's going on at the EEOC, and you can kind of see what's coming towards the private sector. So the EEOC, we talked about the new chair and the new commissioner and a number of her priorities. One of her biggest priorities is what this EEOC with this chair has identified as protecting and defending the biological sex of women, particularly in the workplace as it relates to facilities, restrooms, things like that. And kind of to spin off of that, one of the things that the new EEOC commissioner identified in her opening press statement was a number of changes going on at the EEOC as it relates to pronouns. And so specifically, the EEOC, they used to have this pronoun app where basically
I had no idea. You were telling me this when we were prepping. Yeah, no idea.
My understanding is it was basically an application for EEOC employees that allowed them to identify their pronouns both in internal and external communications with the EEOC. I've seen it. I mean, when we're negotiating charges, doing mediations with the EEOC, you see it that it identifies their pronouns. Well, that is removed. Okay. So that pronoun app is gone. What I find really interesting too is when you are an employee or a claimant filing a charge of discrimination. So you're an employee, you work for a private sector company, and you believe that you've been discriminated against, harassed, what have you, and you go to the EEOC and file a charge of discrimination. Previously, they allowed you to check a box for X, gender. They also allowed you to identify the prefix MX as an option when you're filing a charge. Both of those are gone. So you can no longer identify as X or MX when you're filing a charge of discrimination. Here's a big one too. The EEOC has stated that they're going to revisit the Know Your Rights poster. I mean, everybody in America has the Know Your Rights poster.
Yeah, so the posters that traditionally people would put in the so-called break room or the water, where the water cooler is. Nobody really has offices anymore, so I don't know where you put these.
Right.
And your intranet, yeah.
That's right. And so, I think while they haven't said specifically what's going to change, I think when you look at gender identity, sexual orientation, I mean that's something that they're going to be looking at. And so I think a prediction may be look for an updated Know Your Rights poster coming out from the EEOC. But so that kind of shows you the intent behind the federal agency that is enforcing discrimination in the workplace in terms of their view on pronouns.
So let's say you're a company that has been, let's say, on the forefront of this DEI initiative over the years, and this is coming out, and you've got to tell your workforce. I mean, you've got to tell your workforce that we've got to now go back and watch ourselves and eradicate some of this stuff in terms of stuff that we've been doing, these initiatives. We saw, you and I were looking at an article earlier today. Disney is having almost like an internal civil war over this issue of, how far do we go to conform to the dictates of the current administration. I mean, remember, Disney was famous just a couple of years ago for going to war with DeSantis in Florida over this whole issue of woke endeavors and stuff like that. And actually, I think DeSantis came in and revoked their local government autonomy and stuff like that. It was a pretty big war. Right now, according to this article we were reading today, Disney's having a little bit of a different conversation. People feel that Disney might be conforming too quickly to it. And so what you have is a situation where, okay, you've got all this stuff you got to do, but how do you communicate this internally to your workforce?
Yeah, I mean, it's very tricky, right? Because, you don't want to send out a mass email that some, plaintiff's attorney is going to view as an admission of prior discrimination. And let's unpack what I mean by that is, if you were to send out an email saying, hey, our prior DEI program is no longer lawful under this administration. If you were to say something to that effect, that's an admission that you've been discriminating against people. Again, discriminating against people based on how this administration's viewing it.
Yeah. So a middle-aged white Caucasian employee would say, wait a second.
Hang on.
I didn't get that promotion.
Still within the statute of limitations.
I knew I was qualified for it, and now I've got this memo that they just sent out conforming to the new DEI standards that basically said what I always thought all along.
Yeah, I mean, my favorite line is E in email stands for evidence, right? It's not electronic mail. And so, you got to be careful what you put in there when you're messaging this across to all your workforce. And so, I know you recently dealt with this issue, and I liked how you messaged it. What was your suggestion?
So I mean, you could always go back to the workforce and say, guess what? In light of the new administration, we're doing away with DEI. And, it's really kind of how you message. I mean, to me, what about saying we are recommitting to our efforts to equal employment opportunity in the workplace? Because that's exactly, and that, by the way, equal employment opportunity is not only a perfectly good phrase in this administration. It's the favored phrase because they believe everyone should get an equal opportunity. I mean, that's what they say. So using that phrase and doing away with things like, or another one, removing barriers to equal opportunity. Those are ways that you can word this to your workforce in a positive way that I believe also, would pass muster with the administration. But I will say, I've already experienced it with clients. It is not going to be easy. You've got this phrase, revenge quitting. We've had so many, we've had quiet quitting. During COVID, we've had quiet quitting, quiet hiring and everything. Now we've got revenge quitting where people are quitting their jobs and they're not going quietly. They are going as a form of protest. And this is one of the reasons why they may do it. So we'll see.
Wow.
We do have a couple of questions.
Yeah.
Let's just bang those out real quick. Somebody said, the revocation of Executive Order 11246, but we're still bound by our prime and subprime contracts. And I agree with you about affirmative action and OFCCP still being in these contracts. I will say the executive order basically rendered any enforcement by OFCCP to be a nullity, meaning it no longer exists. And so I don't believe notwithstanding these contracts, I believe we're going to have modifications coming out very, very quickly. So I don't think you are under any duty at this point to report any data to OFCCP. They're not there basically to do anything with it. So that just stands. What was the next one? I understand. So should this reflect ideas saying that? Understand your rescission. Jesus, a long question.
But there is
Rachel, I needed the Cliff Notes version.
Yes.
Still expected to post it. EEO statements. Our GovCon still expected to post EEO statements on our career page. Please, if you only take a few things away from today's hour-long webinar that Nick and I here are doing, EEO is absolutely fine. Equal employment opportunity, absolutely good. Affirmative action, meaning you're taking action to favor one over the other. That's the one the Trump administration is gearing for.
There's one question that I think is worth discussing, and it's a very, very important distinction. And so the question basically asks, with respect to the executive order, whether the rescission removes federal contract obligations to prevent discrimination based on sexual orientation and gender identity. And then the question goes on to talk about the recent Supreme Court case.
Yeah.
Let's clarify that issue because it's so important. Your EEO policies should very much still protect sexual orientation, gender identity. Discrimination of that form is prohibited.
And that was decided by the U.S. Supreme Court in the Bostock decision. Yep. So, that does not change in any of this. So basically, that decision just increased the number of categories that you're not allowed to discriminate against. Now, what you can't do is you can't say, I want to hire more people of a particular sexual orientation, a particular gender identity. That's the problem that you can't do. But you can't discriminate against those, and that's exactly right.
That question touches on the difference between affirmative action and discrimination.
Yeah.
So discrimination is very much alive and well. There's no indication that any of those protected classes are going away with any of these executive orders or this new administration. And so you should very much still have those protected classes in your handbook.
So let's, we got one more quick little topic before we jump into remote work. That's also a hot topic in today's climate. It piggybacks on the issue of communication in the workplace. As you just said, email stands for evidence. Be very careful what you put in writing. They could be discoverable. I want to point one more thing out. It's becoming more prevalent when you jump on a Teams video or a Zoom video to see that AI automatic thing get up there and it transcribes everything that everyone's saying. That is just ready-made transcriptions for potential fodder if you're having conversations about this stuff. Let's just take an example. If you're having a conversation within your recruiting team about, hiring, you've got 3 candidates, they're all qualified, and you say, you know what, I believe blacks are underrepresented in our workplace. It would be great to have that person on our workforce, help balance things out. That's going to be transcribed by AI. First off, if anyone remembers that you said that's illegal discrimination under
probably a disparate treatment claim.
It's a disparate treatment deal.
Absolutely.
But now it's not going to be a he said, she said anymore. It's going to be transcribed by AI. So just be careful. Much like you can't walk down the street without a camera looking at you nowadays. You really can't get on one of these Zoom or Teams meetings or anywhere else and not have a transcription of what's been said.
It's a good idea to take a look at your Teams, your Zoom functions. A lot of times they default to recording. And you can change that. And so I think to your point, with that transcription, it's it's ready-made evidence that some people may say things off the cuff that they wouldn't otherwise put in an email. So
Yeah, no.
with technology, you got to be mindful of that.
We could, Todd was wondering whether or not we could go an hour on this topic. Todd, we just went 30 minutes on this one thing and we could have kept going. All right, we're jumping into what they call RTO, which I love acronyms. I always forget them. Return to office. Okay, return to office requirements and initiatives. And this is a big topic. Before we actually jump into specifics, I want to read from OPM's memorandum that came on the heels of the federal directive to its workforce to go back to the office. I'm just going to read a couple of lines, and I'm reading it not to be incendiary. I'm reading it because I want you to understand how this administration views remote work. And again, you can agree with it or not agree with it. I happen to take big issue with what I'm about to read from personal experience. My wife, the firm here with our hybrid work thing, but it will tell you you don't have to comply with what I believe. You got to comply, unfortunately, with what the administration is saying. Most federal offices presently are virtually abandoned. The vast majority of federal office workers have not returned to in-person work, even through the COVID pandemic years ago. Many federal office workers never show up to the federal worksite at all. Federal office buildings sit mostly empty, particularly Washington, D.C. area, devastating the local economy and serving as a national embarrassment. Virtually unrestricted telework has led to poorer government services and made it more difficult to supervise and train government workers. So that's their view. They believe that this remote work or hybrid work, whatever you want to call it, that really took hold during COVID, they don't believe it's worked. As I said before, I disagree. Yeah. But that's who's calling the shots right now, particularly if you're a federal contractor. Got to play by the rules or you're not going to get paid.
So we know that, and exactly, and that's the perspective of this administration. We know that there is a, across the board, return to work, return to the office for all government employees. There's not been anything specific with the private sector. However, you're starting to slowly see, particularly with government contractors.
Yeah, I've got clients who are being ordered back in.
When you have on-site employees that they're now required to go on. So I'm sorry, employees that were previously remote are now being required to go on to a customer site. And so, there's a host of issues with that. And you can't just flip the switch and say, hey, I've been remote for 4 years, I'm going to come back in person. Yeah. There's some serious legal implications.
There's like a practical consideration of there is no work sites in a lot of these places. The federal government itself divested itself of a lot of its own space, and companies don't even have headquarters most of the time, or maybe not most of the time, but much of the time. Yeah. A lot of our clients coming out of COVID got rid of its leased office space, and now is virtually all remote. And so where do they come to? I guess that's the question.
Yeah, so from a legal perspective, I see two massive issues that are going to be just taking up a lot of time in this coming year. And I think the first issue is accommodations. And secondly, I think contractually, you had companies that hired people at a time when it was a remote position, and now it's changing to in-person. And so, let's kind of unpack those two. Accommodations.
So you're talking about ADA accommodations,
disability accommodations. Yep. I was reading something the other day that the number one accommodation last year, it wasn't standing desk.
It wasn't ergonomical standing.
No, it wasn't
in
that.
This firm, I think it was.
That's right.
Like everyone's got one. Yeah. And a treadmill, apparently.
But you know what? It was remote work. That was the number one accommodation, was remote work. And so, I think look no further than that data, that when you have these mass, return to office initiatives, you're going to receive a lot of accommodations. And I think it's going to be fraught with issues, because here's how I see this happening is, when we use the phrase accommodation, we're talking about a reasonable accommodation under the ADA, which if an individual has a qualifying disability, the company's under an obligation to go through that interactive process to see if they can make a reasonable accommodation without posing an undue hardship. We do this all the time. Yep. And so where I see the biggest issue, or one of the biggest issues with this, is, you're going to have workers who, maybe for the longest time while they were working remote, they had different childcare arrangements, or, you have working parents who, their arrangement with their childcare was doable because they were working remote.
They did away with the commute.
And now they're going to have situations where their government customers requiring them to go on site, and they're going to make an accommodation. The problem is, childcare is not a disability.
Yeah.
And so, I see companies getting themselves in hot water because if you're going to grant accommodations to, working parents to perhaps work remotely, but maybe not to someone who actually has a real disability, that's when you're going to get into inconsistent treatment. You're going to have some serious, serious issues. I also think too, the problem that we're going to have with this is it's pretty clear. As you mentioned, we see it here at our firm. People can work remotely and work very, very effectively. I think that's one of the great benefits from COVID is that we saw the value of remote work and what can come from it. And that, if done properly, work does not suffer.
100%. Yeah.
You're going to have situations where, maybe you've got, Tim, who has been a great worker. The government loves him. He's been working remotely for X number of years. And, the company says, you know what? We know Tim can get his work done remotely. We're going to grant him an accommodation, but we're not going to grant this other person who has a real disability. That's another instance where you're going to run into problems. So I think it's just fraught with accommodation issues.
Logistically, it's going to be a nightmare. It's going to be a nightmare for HR. It's going to be a nightmare for recruiting going forward because remember, for the last 5 years, it was nationwide recruiting. If you're a government contractor, you needed to fill a billable slot, you could look throughout the country and have that filled. Now, with this, somebody just said, if you were 500 miles away from the closest office, what is someone to do?
It's a great question.
It's such a tough question. I would love to be able to say, well, here's what you do. You play this out as long as you can, and maybe something changes, I'm not seeing. They do give a little bit of discretion at the particular agency level to make exceptions. I suspect if you've got a high-performing person with limited with a unique skill set, I think there could be some exceptions, but I think that's going to be very rare. So I wish I had a magic answer to say, oh, here's what you do. You just look under this new executive order that says if you're more than 450 miles away, it ain't going to happen. So this is a very tough thing, I think. I think it's why you're going to see the rise of unions not only in federal contractors, but in the private workforce. Unions have been on the decline for decades and decades and decades, and a lot of time you can understand why. Why does a high-tech worker who's making a great living, why would they need necessarily a union? I'm not trying to diss unions, but I'm just saying, there was a practical reason. Why would you pay money out of your paycheck in order to fund a union when they really don't have, you don't have a need? Unions proliferated during the factory settings where there and where there was injuries and bad working conditions. Well, here's where you need power in numbers, because I do think unions are going to start to garner more support in these workplaces. Remote work is going to be the one that's going to be their hook, I think.
Yeah. I think when companies and HR professionals are being forced with these decisions to basically have to bring people back to an office, I think another thing you got to think about in addition to accommodations is you got to think about their contractual documents. So many of these people were hired back when it was all remote.
Yeah.
And so you have to look at the offer letter, you have to look at the job description. It probably contemplated, them working remotely. The position may have been fully remote. You need to update those. And so, I think looking at the contractual documents now, hopefully everyone's at will. At will is a company's best friend in situations like this, gives the company discretion to kind of make these changes. But, you need to make sure that they're updated to show, hey, the expectation is for you to be in person if that's what the requirement is. And that's just the unfortunate world that we're in.
Yeah, great question that somebody just put in. Can we expect the COR, the contracting officer's representative, to honor disability accommodation requests, especially if you can show that there would not be an undue hardship? Because as we know, for at least the last 4 years, 5 years, that employees have been doing that effectively remotely. It is a real quagmire for companies and for HR departments because ultimately the government, when you say the COR, that is a government employee at the agency that you have a contract with. And if the agency is not even making that call anymore, the administration has made that call. So the Trump administration is telling its agencies, get people back to work. The agency maybe has a little bit of discretion under the executive order to make some limited exceptions. But if they start to make big exceptions, I think that's going to be a problem. So you're really stuck as a company because from the company's perspective, the undue hardship, is not that the work can't get done remotely. The undue hardship is they are in violation of their contractual requirements and their mandate from their client to have everybody back in the workforce. So it's a tough situation. What I'm seeing personally with my clients is, in the short run, agencies are not very willing to buck the Trump administration on this issue. They don't want to ruffle feathers. They don't know if they're on the chopping block themselves. And so nobody wants to be under the microscope right now. I think it'll flesh out over time. I think it will. I think eventually we'll see more accommodations being requested. I think we'll see a little bit more flexibility coming from these contracting offices. But right now it's not there.
Yeah. And I think with this change to RTO, I think what you're seeing is a change that, perhaps these positions being in person, it's an essential function.
Yeah.
And that makes a huge issue when you're talking about granting accommodations. And so basically, if you have a situation where the contracting representative is saying, hey, it's a requirement of this job for you to be in person, it may tie the company's hands.
One thing that's important to note, though, is when we were talking about DEI, we believe that was going to permeate the entire workforce of the United States, starting with federal employees, going quickly to federal contractor employees, and then, as we talked about, the Office of Civil Rights going against private companies. The issue of remote work, though, I really think that's going to be a little bit more limited because there's no DEI, there's no discrimination underpinnings for remote work.
Yeah.
And so I think that's really going to be limited to if your workforce, I don't suspect there's many government agencies listening. Maybe Musk is listening. Who knows? We'll see. Make my orange. But I don't think for pure private workforces, I don't think that this remote thing is going to, these dictates from the federal government, I don't think that those are going to impact what is happening for pure private companies. What do you think about that? Like, in other words, how is the federal government's mandate to get back to work? It's not a DEI issue. It's not a discrimination issue. It's more just like, we think you weren't working. Well, pure private companies don't have the federal government as a contractor. They don't have them telling them what to do in order to get paid.
I mean, there's nothing that's been put out from an executive order or anything like that says, government contractors, private companies need to go back to work. You're seeing companies do it voluntarily, but there's no legal requirement for it. And so, I think we're getting some questions about, companies feeling the pressure to go back to in person. Legally speaking, there's no requirement. I mean, I think the one thing that you need to pay attention to is if you're a government contractor and your customer is saying, hey, this position that was previously remote, we now need them in person. Like, that's where you need to focus on it. But you shouldn't feel an obligation to say, you know what, all of my indirect people or all my people that work out of the office, they need to now come physically in person.
Yeah. So, I don't think you have to open up. One of the questions was, do we actually have to just open an office? I don't think you have to open an office. Like, if you don't have an office, like in this particular case, it was a remote call center with remote employees. I don't think you have to then go and lease space so that they all congregate in one area.
Right.
I think that would be overkill. I think where it really is going to come into play is getting them into the client site, the agency client site, wherever the agency is telling them to go. That's where they're going to have to show up. Regardless of whether or not they've been doing remote work.
Yeah, and the other thing too is, a lot of these government contracts, probably their contracts that were in place well before these executive orders came out contemplated that the work could be done remotely. And so without a modification to that, I just don't see it being as big of an issue in the private sector.
Nope, that's exactly right. Let's see. What else do we have? Same person.
So we're getting some questions about a potential shutdown.
So the two ways to look at this: potential government shutdown on March 13th. You remember they did a couple of months of a spending extension, but that comes back up on March 13th. I think there's two topics that we should talk about as we sort of round things out for the next 15 minutes. One is federal funding based on a government shutdown, but also just federal funding because of the pending funding freezes at specific agencies under the Trump administration.
Yeah. So, I think, things that we see is, we get a lot of questions about, furloughs versus layoffs.
Yeah.
What's the difference? And
I've debated this one for a long time. Yeah.
my take on furloughs, and there's really not like a legal definition of what a furlough
I think it's a
is.
creature of like the federal government. They adhere to like this concept of furlough, and then they try to expand it into the private workplace. It doesn't really fit. Yeah.
I see it work in a very narrow circumstance. And so, okay, what is a furlough? So a furlough is basically you are keeping the employee on your roster, but you're not paying them. And specifically, I mean, it's important that when you keep them on the roster, they do not perform any work whatsoever. I mean, and something as simple as picking up your phone and checking emails, that's going to be performing work. And so if you're truly going to furlough somebody, they cannot do any work whatsoever for the period in which they're furloughed.
So it's like you're breaking up, but you don't unfollow them on all their social media. Is that what it is? You
That's
keep
right.
the lines open just a little bit.
Exactly. Yeah, you're hanging on to a thread. Yeah,
55-year-old guy asking that question.
So, and so, with furlough, I think some things that companies do is, they may allow employees to use PTO or draw down their PTO while they're furloughed. Another thing is, what do you do about unemployment when someone's furloughed? I mean, so particularly if you're talking about a furlough for an extended period of time, I mean, these people have just lost their livelihood. And so the good news is some states do allow you to apply for unemployment or underemployment. Virginia is one of those. They're obviously so familiar with working with the federal government that they do allow Virginia employees to file for unemployment if you are subject to a furlough. So that's a resource available for you.
There's lots of other issues like do you keep a furloughed employee on your health insurance plan? And I personally don't know of any requirement that says if you're furloughed, this is in the private sector, not at the federal government level, that you've got to do X, Y, and Z. It's really just up to the company.
It's up to the company. It's up to your plan.
You've got to look at your health insurance plan. And if it says if your employee is no longer working and is not getting a paycheck, is that somebody that's eligible to continue to get the benefits of being on your health insurance plan?
Yeah.
It's a question you got to look at. So it's very fact specific. Do they continue to accrue PTO? That's another issue. It's really more of a generosity thing or like a specific thing company to company.
The circumstances in which I see a furlough making sense is when you have a reasonable basis to believe that the stop work is going to be temporary. And so, we talk about, this spending freeze and the massive cuts that just are unfortunately going on across the federal government. If that cut is permanent, furlough's probably not the right fit. I think furlough makes sense when, there's a potential shutdown, something like that, where you have a reasonable belief that, hey, this is temporary. Our people are going to be out of work for what we hope is just a short period of time. You don't want to go through the hassle of having to onboard everybody again. And, the other reality too is, you may lose good people. And so
it allows you to kind of let them down easy a little bit with the hopes that they're coming right back in.
It allows you to retain your people, allows you to you don't have to go through background checks, all that stuff. And so, it can preserve resources.
Yeah, so that's a great point you just raised. Security clearances, if you cut the cord specifically, you may have to, that may have implications for who holds the security clearance. So there might be some very much strategic reasons to
absolutely
do this.
Yeah. And so I think if when you're looking at there's been some cuts. If furlough's not right for you and you need to go the layoff route, I mean, I think the two big things that we deal with a lot that come into play, it's the Federal WARN Act and then the Older Workers Protection Act if you're going to be providing severance. And so let's kind of talk about those. So
you start with WARN, I'll do the older.
Yeah. So the WARN.
That's the older guy here.
Yes. So the WARN Act. So it's important that it does not apply to all companies. It only applies to larger companies with 100 or more employees. And so if you as a company have reason to believe that there's going to be a mass layoff, you've got to give them 60 days advance written notice of either a plant closing or a mass layoff affecting the workplace. And those are all defined terms. But so if you have a plant closing that's going to be affecting 50 or more employees, you've got to do the WARN Act notice. If there's a mass layoff impacting, I think it's a third of the workforce, you've got to give those notices. And so if you're a large organization where, let's just say you have a facility in a different state and you have to shut down that entire facility and it's got 50 or more employees, you're probably going to have to give a WARN notice.
And one caveat with that is a lot of states have their own mini WARN Act.
So I think
you've got to
Georgia has
know,
one, yeah.
You've got to know, like, where your employees are. It's where they're working. It's where they're working is going to implicate whether or not you have to comply with what they call these mini WARN Act. Let's talk about the Older Worker Benefit Protection Act. Okay, so let's just break this down. Acronyms, BPA. So when you terminate somebody, let's just say you have to do a layoff here as a result of federal funding freeze, something along those lines. The agency has gone away. That's very much a possibility. Yeah. If you're going to give them any severance and require them to sign a release, you've got to have specific language. And if it's just a one-off, if one person's getting terminated, you've got to give them, if they're 40 and over, okay, because that's what they consider 40 and over.
Yeah.
Are you 40 yet?
Yeah. About to be. Yeah.
40? Yeah. Darn it, man.
It's going to be a fun summer. Yeah.
Man. And I still beat you in bowling? That's unbelievable. So the Older Worker Benefit Protection Act says you've got to give an employee 40 or over 21 days to review it. And then after they sign a severance agreement, they still have 7 days to revoke it. If it's part of a group layoff, which they consider 2 or more, which I think is a little bit obtuse there, but they consider 2 or more to be a group layoff, you have to then extend that to 45 days to consider. They still have that same 7-day revocation. And you've got to give them data on the people and their ages that are both being terminated and the ones that are staying behind and keeping their jobs.
Yeah.
So that when somebody's evaluating this and giving up their rights under the Age Discrimination and Employment Act, that they have a knowing data in front of them in order to do this.
They want it to be knowing and voluntary. That's the standard. So they want to know, okay, who was considered, who was selected.
Yeah.
That's the data that you have there. And so, I think one thing that's also important too is when you're putting in that severance agreement, make sure you put in the language that says, any changes to the separation agreement.
Oh my God.
Because otherwise then you're going to be restarting the clock every single time.
Yes. The flip side of that I always tell attorneys if I'm negotiating this with is, your person doesn't get paid until that 8th day after they sign. So if they want to take their full 45, or if they want to argue with me that it has reset and now you got 90 days, that's fine. You're just not getting paid until the 8th day. So theoretically, you could get an agreement and then have a negotiation, and you would not see any money until 98 days later. So not a smart move.
And one thing to note too, you mentioned, what's considered a group termination under the Older Workers Act. It's 2 or more. It's a very low bar. What I actually have seen some clients ask, and you can't do, is, if you space out the terminations, can you get around? and the answer is no. I mean, they're going to look at, okay, what was the reason for this termination? Kind of what's the set of facts that's giving rise to it? And if we're talking about a group termination because of these government cuts, they're going to look at, not necessarily when it was done, but were these cuts kind of all relating from the same issue from the government cuts?
Yeah. The one thing I would say, and I've grappled with this a bit on that point. I'm glad you brought it up. See, we're like geeking out on employment. Is the group layoff has to really be because of an outside reason. Like, in other words, it has to be it can't be employee related. If you have a couple of really bad performers, that's not really a group layoff, because it's like, you could space one out this day, this day, this day. It's really, are you doing a layoff? What do you hear?
No, I'm not sure what that is.
Yeah. I hear some noises here.
Yeah.
But it has to be kind of an outside thing. Like, so the company's going through layoffs because of its own internal or because of the federal government, like we're talking about now. Okay, good. We've got
like 6 more minutes.
Let's talk about immigration enforcement, specifically I-9 enforcement. It's something I don't believe I've ever uttered in this studio in how many years since we built this, Todd? I-9 verification and audits, it's not something, it's important. It's basically, you've got to get that paperwork when somebody starts to make sure that they're eligible to work in the United States. Why does it matter now? Is because immigration is hot topic under the Trump administration. We believe under Hire American initiatives, we believe that you're going to see more I-9 audits. I have not looked at the data, but I suspect that this has not been a hot topic for years, if not decades. I mean, it's important, but it hasn't been a hot topic. I believe we're going to see a lot more I-9 audits under the Trump administration.
And on that topic, we're getting a question about the I-9 verification process. And so, one of the things that became popular during the COVID era were these remote I-9 verifications, right? Where you could basically, go behind a screen and kind of verify it that way. Do we know? Is that still allowed, or what's our thoughts on that?
Yeah, it's interesting because normally the way the I-9 usually worked is you show up on your first day in a physical office and you bring either your passport or your license and this and that, and it says, hey, I'm authorized to work in the United States, so we're all good. It takes 10 minutes and it's all done. Well, COVID, there were no workplaces. People were not showing up in a physical space. People were all remote. And so the federal government temporarily said, Department of Homeland Security temporarily said, you know what, we recognize that we're not seeing people face to face. And so you can do this by video screen. That's not a problem. You can do it by video screen. And then in 2023, they decided to make this permanent. And so there are some caveats. You've got to be a qualified E-Verify user. E-Verify is the system that is used to check backgrounds to make sure people are indeed eligible to work in the United States lawfully. You're supposed to do it by live video, so it would be like you and me on a video, and you'd be kind of showing the stuff. And you still do have to keep records, physical records. After the fact, you're supposed to get copies of what you saw and keep those. So HR still has to keep all of that stuff. So still an important thing. And what do we got? Should GovCons wait for contract months before they stop telework or remote work? Well, I mean, I guess technically right now, government contractors have not been ordered back. I mean, this is only impacting the federal workforce. Now, have we seen in practice that it is happening? The agencies are requiring people to come back to work. So I think you just got to take your cue from the agency at this point.
I don't think you need to make a presumption that they're going to require you to go back to the office. I mean, I think, you know, if your contract allows remote work, continue to perform under your contract. Under the radar until you're forced to.
I don't know that this one. Let's see. Should I even bother with registering to perform I-9 verification? Should I even bother with registering to perform I-9 verification virtually? I may have just covered that. I would say it does make sense because I still think we're going to have a workforce that's fairly spread out. It's just we'll see what shape that takes, but it just makes it easier, I think. So become a qualified E-Verify user, and I just think it'll make your HR life a little bit easier. Last topic, as we are about to 3 minutes left.
So I mean, I think one of the topics that we wanted to touch on was AI and just basically the increased focus on that. I mean, there's been executive orders issued without, in my view, not a ton of detail, just kind of more a preference to encourage AI in the federal government and in the private sector. And so, you know, I think we also saw that there was some AI guidance issued by the DOL and EEOC that has since been scaled back. And so I think it's pretty clear under this administration, you're going to see a renewed focus on pushing AI. It's not without its legal risk, though. You got to know.
HR probably already uses and doesn't really even realize for the most part that they use AI. I mean, so many of these recruiting tools have AI built into them. You know, as you've noted, the anti-discrimination laws still apply. But this is an area where at the federal level, the Trump administration has said full steam ahead on AI. So they're not going to, the Biden administration was looking to put in some guidelines and some guardrails and stuff. And let's kind of proceed a little bit like, you know, cautiously. Trump administration says, wait a sec, did you see what China just did with overstepping us on AI? We want full steam ahead. But this is an area where the state laws are going to come into play. New
York, so there's already some states that are going out there saying, you know, you need to notify people that they do use AI. There's got to be basically a disclosure point. But I think New York's one of them.
If you're interviewing somebody and you're actually, you know, running that interview using any AI, or if you're running their application anywhere through AI, you've got to notify them if you're doing it in certain states. And those states are growing, by the way.
And I think, I mean, the benefits of AI speak for themselves. I mean, no one's going to sit here and say that we shouldn't be using it. I mean, AI, there's some real benefits to it. I think one of the things that you can do is just do regular audits of it. I mean, you know, I see a big issue with AI in terms of disparate impact claims. And so, you know, you can have this face neutral policy that utilizes AI, but it may be disproportionately impacting, you know, certain protected classes. And so don't put your head in the sand. You know, if you're going to use this AI software to help with recruitment, hiring, onboarding, that's great. Check it.
know how it was developed. I mean, if the development side, if you just outsource your development of your recruiting tool to some AI creator, and they have only included certain zip codes in the recruiting process, and those zip codes, as you just said, would disproportionately exclude, let's just say, minorities or whomever. If you're a company in Palo Alto and you're only recruiting a few square miles away from that area, Stanford University and stuff like that, you're going to get very much a homogenous applicant applying. You better make sure you know how it was devised, what went into the algorithm. Wow, are we right on time? I
think we
2 o'clock, Nick. Yeah. My goodness, that's good. I think we should take the rest of the afternoon off.
That's right. Yes.
Unfortunately, that's not going to work. But anyways, great discussion. As I said a year ago, we were talking about DEI and remote work. Today we did the same, and I suspect our next quarterly one is going to be. Do we do these quarterly, Rachel, or is it every 2 months? I forget. I can't even keep my schedule straight. We're going to be talking about DEI and remote work still.
That's right. Yeah, it was
because this ain't going away.
Really, really good discussion. Thank you all for tuning in. I mean, this is a lively topic that we're going to be getting a lot more information that comes out. I mean, stay tuned. We're going to be pushing it out, but really, really good discussion.
Yep.